The tripartite distinction of search, experience, and credent goods, originally made by Philip Nelson in 1970, helps categorize different features of products or services based on when consumers are able to assess their true qualities. Search goods have the kind of attributes that you can fully perceive prior to purchase. That is, before you enter into a contract. If what you see is what you get, then it's probably a search good. Another sign of search goods is that you don't care much about the reputation of the seller because you can judge its quality by inspecting the product yourself. A map of the United States is probably a search good, so is a photocopy of the Declaration of Independence. A painting or a chair might predominantly be search goods. The qualities of experience goods, in contrast, can only be ascertained after purchase. The classic example might be a razor blade, where you only learn for sure whether it's sharp after you buy it and drag it across your skin. Or the quality of laundry bleach can only be judged after you've put at risk your clothing. Consumers can only learn the quality of experience goods as they use or consume the goods. Finally, with credence goods, the quality of an attribute is difficult to ascertain even after an individual consumer uses it. The claim that a light bulb has an expected life of 10,000 hours, or the asserted benefits of vitamins, or frequent oil changes are difficult for an individual consumer to judge even after using them. How do I know whether my vitamin C tablets are working? How do I know that this just wasn't an abnormal light bulb and that on average they last 10,000 hours? While economists tend to apply these terms to goods or products, I think it's helpful to think of the concepts as applying to different attributes of something that you might buy. A particular product might have a mixture of attributes that can be evaluated at different times and thus partake of each of these categories. But some products or services predominantly have just one kind of attribute, as is depicted in this slide created by Doug Bowman, which claims that clothing predominantly has search attributes, restaurant food predominantly has experience attributes, and that legal services predominantly have credence attributes. Keeping in mind the differences between search, experience, and credence attributes can help tailor legal rules. With search goods, the law needs to foster credible advertising so that consumers can expect that when they respond to an ad for a product, it will be there. With experience goods, it's important for the law to foster seller reputation, for example, by establishing robust trademark law. I don't want to trust my Letterman's jacket to just any laundry bleach. I'm willing to pay more for a razor manufacturer that I trust before I press its metal to my flesh. With regard to credence goods, there's a larger role for law to audit the aggregate quality to verify whether the attribute in fact exists. Thus, the FDA monitors the safety and effectiveness of various pharmaceuticals. For discussion, can you think of examples where legislation or regulations have search, experience, or credence attributes? And if so, how should the law respond? The legal regulation of information acquisition and disclosure is a vast and complex area comprising intellectual property and much, much more. But today, I want to talk first about three dichotomies, the first two of which are captured in the following 2x2 table. The columns in this table represent two different ways in which information is acquired. Some things we learn through effort. such as the intricacies of tax law. This type of information is deliberately acquired. Other pieces of information we come to know without much, if any, effort. Casually acquired information is information that's difficult not to know. It doesn't take much effort to know that there's a country called the United States of America. Indeed, it would require a considerable amount of effort not to know this fact. Tony Kronman, who, by the way, taught me bankruptcy a long time ago, he emphasized the difference between deliberately and casually acquired information because we can require the disclosure of casually acquired information without much risk that the potential discloser will remain willfully ignorant. That's not the case with deliberately acquired information. If we force, for example, sellers of used cars to disclose what they know about their car before selling it, we might expect that these sellers will not take the steps to acquire the information in the first place. So back to the table. The rows of the table represent two different effects of information disclosure. Sometimes the disclosure of information will create value by allowing the recipient of the new information to take better care or make better allocative choices of what to buy or sell. Disclosure of information in the stock market might lead to more accurate prices that might cause money to ultimately flow to more appropriate investments. This would be value-enhancing information. In contrast, other types of information do not increase value, but merely affect how the value is distributed among people. This would be redistributive information. Bob Cooter and Tom Ulen, by the way, I routinely used to beat Tom Ulen in racquetball. They emphasize this distinction because we might want to encourage the acquisition of value-increasing information and actively discourage the acquisition of redistributive information because it merely redistributes value and then costs money to acquire often. The individual cells in this table include examples of these four permutations created by this 2x2 box. KFC's secret recipe represents a trade secret that was deliberately acquired by the corporation, I guess by Colonel Sanders, and which enhances the value of the chicken. A home buyer might want to know that the seller needs a hospital operation solely because knowing this would give the buyer an ability to demand a lower price. The guy needs cash quick to do the operation. This kind of information might be deliberately acquired to search for this, but it would be redistributive because its main effect is just changing the price at which you'd buy the house. Hearing about the War of 1812 ending is a reference to Laidlaw versus Oregon, a Supreme Court case which Tony Kronman argued involved casually acquired information because one of the litigants just happened to hear an early report that the Treaty of Ghent had just been signed ending the War of 1812. The news is value enhancing in the sense that it might cause better allocative investments. In that case, hogsheads of tobacco, these are hogsheads of tobacco, were rotting on the docks of New Orleans because of the British blockade. But because the war was ending, the blockade was about to be lifted. Can you guess what is about to happen to the New Orleans price of tobacco? Finally, a dealership's knowledge of its own markup is casually acquired information because it'd be hard for a dealership not to know the price at which it purchased the car and the price at which it's selling the car. Disclosing the markup to consumers would be primarily redistributive, possibly in allowing the consumers to bargain for a larger share of the gains of trade. A final dichotomy, emphasized by Steve Chevelle with regard to information disclosure, is tied to contracting. As a descriptive matter, the law is much more likely to require sellers to disclose information than to require that buyers disclose information. Thus, while the phrase caveat emptor, let the buyer beware, is better known, the phrase caveat venditor, let the seller beware, is more relevant when it comes to undisclosed information. A landlord might have to disclose that someone previously died in an apartment, but a renter usually need not disclose that she had previously been convicted of murder. So what are the possible ways that the law can regulate the disclosure of information? If you think the answer is that the law has to choose between mandate disclosure or not, you're way off base. Here are 5 possible regimes where the law can affect disclosure. It can prohibit disclosure. The law, of course, prohibits the disclosure of classified security information. In my lecture on the veil of ignorance, I suggested contexts that keeping decision makers in the dark can lead to less biased decision making. That's why we prohibit students from disclosing their names on exams. We alternatively might prohibit just the credible disclosure of information. And this, more subtly, the law sometimes allows disclosure but undermines the credibility of any claims. This is one effect of the secret ballot. I could tell the president, I promise I voted for you, but talk is cheap and non-credible because I can't verify that I in fact did. And another kind of legal regime is laissez-faire. Under a laissez-faire regime, it allows the possessor of information to decide whether to disclose or not. This might or might not include full freedom of contract in which the possessor of information commits in advance whether to maintain confidentiality or disclose to the public or to particular people. And another regime would be to mandate disclosure of what you know. The law requires pharmaceutical companies, for example, to disclose adverse events about their pharmaceuticals about which they become aware. The important limitation here, though, is that the companies only have to disclose what they know. And finally, the most supercharged kind of disclosure regime is a mandate to disclose what you know or should have known. This is mandatory disclosure on steroids. It requires disclosing what you should have known. That kind of requirement responds to the concern of willful ignorance. If you require used car sellers to disclose what a mechanic tells them is wrong with their car, they're likely again to avoid taking their car to a mechanic before selling. But if you require them to disclose what they should have known, and they should have known what a mechanic tells them, you can avoid the problem of deliberately non-acquired information. So for discussion, which of these legal regimes is best deployed in each of the permutations described above, including with regard to buyers and sellers? P.S. You can hear about a hypothetical where a professor selling a car tries to remain uninformed in my lecture about the ex ante and ex post distinction. In today's lecture, I'm going to speak about 4 paradoxes and dilemmas that have legal applications: the prisoner's dilemma, the Condorcet paradox, the Monty Hall problem, and the Simpson's paradox. Knowing about these perverse possibilities is useful because you might be able to argue that they're at play in new legal contexts that you encounter. You may already have learned about many of these in college and can skip parts of this lecture. But if you haven't heard of them, you're likely to hear about them in law school. First, let's look at the prisoner's dilemma. It's the most famous game in all of game theory. Imagine two prisoners are being interrogated in separate rooms about a bank robbery. Each has the choice of remaining silent or confessing that the two of them committed the heist. The choice is often referred to as cooperating or defecting. Remaining silent is the cooperating strategy because if both prisoners cooperate and remain silent, it becomes harder to convict them of a serious crime. The prosecutor who wants to disrupt their cooperation offers to let a prisoner go free if he or she is the only one to defect and confess so as to secure a severe sentence for the other prisoner who remains silent. The following table shows the payoffs, here meaning the time served to each prisoner under the four possible permutations of cooperation and defection. The striking result is that each prisoner does best defecting regardless of what she believes the other prisoner is going to do. If you're prisoner A and you believe prisoner B is going to remain silent, then you go free if you defect. But even if you believe that prisoner B is going to defect, then you still minimize time served, 2 versus 3 years, if you defect. So even though the prisoners are jointly better off by remaining silent, each serves only 1 year, the dominant strategy is for both to defect, in which case they're going to serve 2 years. 2 points are worth mentioning about this game. First, and chillingly, both prisoners might confess even if they are innocent. If the prosecutor can credibly threaten these outcomes, even innocent prisoners will find it rational to falsely confess to crimes they didn't commit. Second, I described the game with the prisoners being kept in separate rooms without the opportunity to communicate. But so long as binding contracts or credible threats of retaliation are not allowed, communication between the prisoners will not change the result. Communication is cheap talk, and if the prisoners are then called upon to simultaneously choose, the rational game theoretic response is still the defect. A co-author of mine, Rob Gertner, has written an empirical piece about a game show, Friend or Foe, in which prior communication often fails to produce cooperation. Finally, you should be on the lookout for prisoner dilemma strategic interactions in other contexts. In antitrust, the choice of cartel industry members on whether to defect by chiseling on the cartel price or cooperate by maintaining the price or quantity quotas creates a similar prisoner's dilemma dynamic. In property law, the prisoner's dilemma is closely related to the tragedy of the commons, which gets its name from the tendency of group owners to tragically overuse common land. The fishing industry would be better off if it limited the number of fish taken in a particular year, but individual boats have a prisoner dilemma-like incentive to defect, leading to overfishing. An example is shown here where the overharvesting of cod in the early 70s decimated the available population to regenerate itself in later years. Several professors have added a prisoner's dilemma temptation to their final exams. The professor adds a question that says, select whether you want 2 points or 6 points added onto your final paper grade. But if more than 10% of the class selects 6 points, then no one gets any points. So for discussion, can you think of other contexts where the prisoner's dilemma temptation to defect arises? Is it ethical for professors to put students in a prisoner's dilemma? Our second perversity is the Condorcet voting paradox, which gives rise to what is called Condorcet cycling. Suppose 3 voters, 1, voter 2, voter 3, need to choose between 3 candidates, candidate A, candidate B, or candidate C, and the voters have the following preferences. Voters 1 and 2 each prefer candidate B to candidate C. For voter 1, candidate B is the second choice and candidate C is her third choice. For voter 2, candidate B is the first choice and C is the second choice. So that candidate C would be eliminated in a majority rules democracy if the voters were asked to choose solely between candidates B and C. But inspection of the table shows that a majority of voters also prefer C to A, and a majority of voters prefer A to B. These preferences give rise to a Condorcet paradox because A is preferred to B, which is preferred to C, but which is preferred back to A again. No candidate is preferred to both of the other candidates by a majority. The fact that a majority of the group prefers A to B and a majority prefers B to C does not imply that a majority prefers A to C. These preferences give rise to Condorcet cycling because if pairwise voting continued until a clear winner arose, the voting would never end. It would keep cycling. Condorcet cycling emphasizes the importance of procedure. The person who sets the agenda can determine the outcome. An agenda setter who wants candidate B to win would just need to have an initial vote between A and C and have the winner of that contest, which would be C, then face off and lose to candidate B. The Condorcet paradox is also related to the arrow impossibility theorem, which proves that there is no satisfactory voting method, or for that matter, a non-voting method of aggregating preferences. Ken Arrow, by the way, is a real hero of mine in economics. There was a time when he left a message on an old-time answering machine asking me to give a paper, and I still have that tape recording of his voice. That's how much of a fanboy I am. The third perversity I'm going to talk about is Simpson's paradox, which has direct application to questions about how to best test for discrimination. The 11th Circuit wrote that the paradox raises the possibility of, quote, illusory disparities in improperly aggregating data that disappear when the data are disaggregated, unquote. For example, scholars analyzing 1973 admissions data from the University of California at Berkeley uncovered, quote, a clear but misleading pattern of bias against female applicants, unquote, because the uncontrolled aggregate analysis showed that women applicants have a lower overall acceptance rate than men applicants, even though many of the departments admitted women at a higher rate than men. A stylized version of this university example can help us understand how the Simpson's paradox operates. Imagine there's a university with just 2 graduate departments, math and English. Of the 1,000 women who apply for graduate admissions, imagine that 90%, 900 out of the 1,000, apply to the English department, and that only 10%, 100, apply to the math department. In contrast, imagine that there are 1,000 men applicants, but they are evenly divided in their applications between the 2 graduate departments. 500 apply to math and 500 apply to English. Finally, imagine that in each department, the admission rate for women is higher than that for men, but that the admission rate in the English department for both male and female applicants is markedly lower than in the math department. Specifically, imagine the departments admit men and women at the following rates as shown in this graph. Under these conditions, the overall admission rate of men applicants at the university would be 50%, while the overall admission rate of women at the university would be only 28%. The paradox in this example is that even though women have a higher admissions rate than men in each of the departments, 82 versus 80% and 22 versus 20%, they nonetheless have a lower admission rate for the university as a whole, 28% versus 50%. Failing to control for department effects in a statistical analysis, and here the department effect that's most important is that the English department admits a lot fewer applicants than the math department. Failing to control for department effects in a statistical analysis, such as a regression, would seem to give a false indication of gender disparity disfavoring women, when in fact women have a statistical advantage of 2 percentage points in each department. But this concern about the possibility of a Simpson paradox ignores the important differences between two different kinds of discrimination claims: disparate treatment claims and disparate impact claims. In a disparate impact case, where intentional discrimination need not be proven, defendant policies that produce unjustified racial or gender disparities in the aggregate may give rise to liability even if there is no disparity in subsets of the data. Thus, in a stylized version of a famous civil rights case called Griggs versus Duke Power, which was decided by the U.S. Supreme Court, if an employer hiring janitors had hired 100% of black janitors with a diploma and only 99% of white janitors with a diploma, and 1% of blacks with no diploma, and 0% of whites with no diploma, there still might be a disparate impact problem. And it's because the Supreme Court said that having a diploma was not a business justification for an employment decision with regard to hiring jobs like janitors. The problem is that the policy of having such a higher employment of people who had diplomas worked a disparate impact against African Americans, who were much less likely at this time period to have high school diplomas than whites. And so that overall, only 28% of blacks were being hired. This is a hypothetical that I constructed, versus 50% of whites being hired, even though within each category there was a small 1% advantage for black applicants. If one has the appropriate appreciation of disparate impact, there still could be a concern that this raises a disparate impact problem. Similarly, in the foregoing university example, the university's policy of admitting a much higher proportion of math applicants than English applicants has an aggregate disparate impact on women applicants because women applicants disproportionately apply to the English department. In a disparate impact analysis, controlling for the tendency of different departments to admit students at different rates would only be appropriate if the university could establish a business justification for its much, much lower acceptance rate in the department dominantly applied to by women. At the end of the day, a Simpson's paradox discrimination reversal only can occur if some uncontrolled characteristics, like the applicant department or the applicant diploma status, is correlated with the plaintiff's protective class and disfavored by the defendant's decision-making. From a disparate impact perspective, the key issue is not the possible reversal of the estimated disparity, but whether the defendant is justified in disfavoring a category that is disproportionately represented by the plaintiff's class. The fourth and final perversity makes a great bar bet. It's the Monty Hall problem, inspired by a game that the longtime host of Let's Make a Deal routinely played with audience members. Here's a modified version of the setup. Suppose you're on a game show, and you're given the choice of 3 doors labeled 1, 2, and 3. The host, Monty Hall, explains to you that behind one door is a fabulous prize, but behind each of the other 2 doors is only a smelly goat. You can pick any of the 3 doors, and after you pick, Monty says he will always open up one of the unchosen doors and show you that it contains a goat. This is possible whether or not you've chosen the right door or not. You will then have the chance to switch from your original pick to the other unopened door. Now, go ahead and pick a door, say number 1, and then Monty in this example follows through on his promise and shows you that door number 3 has a goat behind it. Monty then turns to you and asks, do you want to stay with door number 1? Or would you like to switch to door number 2? What do? Well, most people, unless they've been taught this game in school, have the intuition that it doesn't matter whether you switch. Once door 3 is revealed to be a goat, there's a 50-50 chance that either of the other doors will contain the prize. That intuition is incorrect. It turns out that switching doors doubles your chances of winning the prize from 1/3 to 2/3. This can be proven theoretically, and indeed there's a cool proof of it by the autistic protagonist in the book, The Curious Incident of the Dog in the Nighttime. But you can also show it empirically with a deck of cards. Play repeatedly with a friend, and every time take the option of switching. If you never switch, you get the prize only 1/3 of the time, because there's only a 1/3 probability that you would have guessed the right card initially. You'll quickly learn, though, that if you switch every time, you get the prize 2/3 of the time, because that's the only. If you only get the prize 1/3 of the time if you don't switch, then you have to get it 2/3 of the time if you switch. You can turn this card game into a profitable bar bet. I've played it where I promise to pay $1.10 every time I lose if the other bettor promises to pay me $1 every time I win. And we keep playing until one of us gets down and loudly pronounces in front of the rest of the bar that the other is truth and righteousness itself. The Monty Hall problem is deeply related to law because at heart it's a question about how we make evidentiary inferences. Most people wrongly discount the importance of the seemingly irrelevant piece of evidence that there is a goat behind door number 3. Like most questions of evidence, the problem has a lot to do with Bayes' theorem, which teaches how to update your beliefs based on new evidence. If you've never heard of Bayes' formula, you might also want to Google it. The standard of review is the amount of deference given by an appellate court to various determinations made during an earlier part of the adjudication. There are 3 basic review standards: clearly erroneous, de novo, and abuse of discretion, that grow out of 3 different kinds of lower court determinations. Questions of fact tend to be reviewed on what is called a clearly erroneous basis. Questions of fact are for the jury to decide, but you should keep in mind that at bench trials, judges can also decide questions of fact. The trier of fact can assess the demeanor of witnesses and hence has an advantage over appellate courts in deciding factual questions because the appellate courts only have before them the paper record. Because the trier of fact is better placed to make factual determinations, appellate courts will only set aside a question of fact determination if it is clearly erroneous. Thus, even if the appellate judge believes that she would have found differently as a trier of fact, she as an appellate judge may be forced by the clearly erroneous standard to uphold the finding. A related but less deferential standard of review, substantial evidence, calls upon an appellate court to uphold a jury's question of fact determination unless the determination is not supported by substantial evidence. But if you wake me up in the middle of the night and ask me what's the standard of review for questions of fact, I'm going to tell you it's the clearly erroneous standard. In contrast to questions of fact, lower courts also make determinations about questions of law. At an initial trial, questions of law are for the judge to decide. Whether the defendant sold synthetic marijuana would be a question of fact for the jury. Whether selling spice violates a criminal statute is a question of law for the judge to decide. In contrast to questions of fact, the lower court is deemed to have no advantage, evidentiary or otherwise, in deciding questions of law. Accordingly, appellate courts gives absolutely no deference with regard to lower court determinations about questions of law. Questions of law are reviewed on a de novo basis, meaning that the appellate court should decide those kinds of questions as if it were deciding the issue from scratch, de novo. The reasoning of the lower court's analysis should only be deferred to the extent that it's persuasive. Appellate courts, as a theoretical matter, should treat the reasoning of the trial court as though it were an additional brief from one of the litigants, something to be considered but not deferred to. Because of the stark difference between the deference given to questions of law and questions of fact, it's crucial for appellate courts to be able to distinguish between what questions fall into which categories. The problem of categorization is made all the harder, it was made all the harder, as there is also an intermediate category of determinations called mixed questions of law and fact. The treatment of these intermediate questions are annoyingly complex, but if I had to summarize while standing on one leg, I'd say appellate courts give clearly erroneous review to mixed questions when factual issues predominate, and give de novo review when legal questions predominate. Or the realist in me suspects that courts might apply a sliding scale of deference depending on the extent to which factual questions or legal questions predominate. There's one last important standard of review, and that is the abuse of discretion standard. When a judge is given the discretion to do something, such as issue an injunction, an appellate court will only overturn that action if it determines that the original act was an abuse of discretion. Somewhat surprisingly, for most of our country's history, there was no well worked out jurisprudence of what constituted a question of law or a question of fact, much less what constituted a mixed question of law and fact. But then in the 1980s, the judges on the Seventh Circuit Court of Appeals decided informally to include in each opinion an explicit discussion of what standard of review they were applying with regard to each issue on appeal. This informal circuit court rule had a dramatic impact on the law. Suddenly, there were hundreds of cases explicitly grappling with what was the appropriate standard of review. The West key number system, which you'll learn catalogs under different key numbers which cases address which specific issues, suddenly saw an explosion in the number of cases discussing the standard of review. Now, nearly all the circuits have adopted the practice, and appellate litigants explicitly brief the standard of review issued that should be applied to, in each appeal. So the tool here, as you're reading appellate decisions, is to, especially older decisions, is to pay attention to which standard of review the court applied to particular issues. In the older decisions, they won't tell you which one they are applying, so you're going to have to infer it. More specifically, when you're reading an opinion, you should ask, did the court give adequate deference to jury determinations of factual questions? More generally, learning the standard of review reviews allows you better to appreciate how our system limits and narrows the grounds for appeal. If you've won below on a factual issue, you're in a much better position than if you've won on a question of law. And now for discussion. Should appellate deference be as great now that technology is providing HD videos of witness demeanor? When learning the rules that govern a particular cause of action, it's important to learn not only the individual legal elements upon which liability is contingent, but also to pay attention to which litigant has the burden to establish the existence or non-existence of each element. As a general matter, the moving party, the plaintiff or prosecutor, will have the burden of establishing each of the elements, but often the defendant will have the burden with regard to affirmative defenses. And as we will see, the type of burden can vary in important ways for elements at different times of trial. To begin, it's helpful to keep in mind the difference between the burden of production and the burden of persuasion. A burden of production is the burden to come forward with some kind of evidence. A party fails to satisfy this burden if he or she fails to introduce any relevant evidence on the subject. In contrast, there are traditionally three different burdens of persuasion. The most difficult burden to satisfy is proof beyond reasonable doubt. This, of course, is the standard in criminal cases. We place this heavy standard on prosecutors because our society would, to paraphrase William Blackstone, rather have 20 guilty people go free than have one innocent be convicted. Blackstone, B.T. Dubs, was the first great legal treatise writer. An economist might similarly say, because the harms of false positives are far greater than the harms of false negatives, we make it harder to convict. Courts annoyingly have resolutely refused to express proof beyond reasonable doubt as a particular probability. But if you had to, you might think of this as requiring prosecutors to prove guilt by more than a 99 or 95% likelihood. The most lenient burden of persuasion is the preponderance of the evidence standard. Here, the requisite element must be proven to be more probable than not. This can be quantified as a requirement of something more than 50% likelihood. In between the preponderance and reasonable doubt standard is the third and final burden of proof, the clear and convincing evidence standard. In many ways, we don't know much more than that this standard requires more than a preponderance and less than proof beyond reasonable doubt. It has been used in a handful of circumstances where the defendant might bear a stigma from being found civilly liable, or where there are irreversible consequences of a court action. For example, courts have sometimes required clear and convincing evidence from a plaintiff before finding a defendant civilly liable for fraud, or in paternity cases. And courts require clear and convincing evidence of intent before removing hospital life support. However, recently, the Department of Education has required universities in non-criminal disciplinary actions regarding allegations of sexual assault by students to cease using a clear and convincing evidence standard and only require complainants to establish sexual assault by a preponderance of the evidence. Indeed, this figure is taken from the University of Pennsylvania's Office of Student Conduct and says that clear and convincing evidence, quote, is when it is highly probable, substantially more likely than not, reasonably certain that the alleged incident occurred. It does not mean that there is not some other possible explanation. It means that the explanation put forth by the university is convincing, unquote. Let's now use a stylized civil suit to think about how these burdens of production and persuasion play out. Even before discovery or introduction of evidence, the moving party usually has what might be called the burden of allegation. For example, If a civil cause of action has 4 elements and the plaintiff's complaint fails to make an allegation that the 4th element is present, the defendant can demur, or in modern parlance, move to have the case dismissed for failure to state a claim. By the way, be sure to pronounce demur with 2 syllables and without palatalizing the U. The legal term demur can be used as either a noun or verb. She filed a demur or he demurred. The non-legal word demure is an adjective which means modest or shy. Now, imagine that a civil plaintiff has satisfied what I think of as her burden of allegation by satisfactorily making allegations with regard to the requisite elements in her complaint. Then, at the close of discovery, but still before trial, the defendant can move for summary judgment. If the defendant can show that the plaintiff has failed through discovery to produce sufficient evidence to show that a genuine issue of material fact exists with regard to one of the elements that the plaintiff has the burden of establishing at trial. It's important to remember that summary judgment can also be brought by the plaintiffs with regard to issues that it bears the burden of establishing at trial, and with regard to affirmative defenses that the defendant has the burden of persuasion of establishing at trial. There will analogously, these motions for summary judgment will analogously be granted if the plaintiff can show there exists no genuine issue of material fact with regard to the issue that the plaintiff is moving on. So then, during the civil trial, if the plaintiff, during its case in chief, fails to introduce sufficient evidence so that a rational juror could conclude that the plaintiff had met its burden of persuasion, usually preponderance of the evidence, with regard to a particular element, then a court may direct a verdict for the defendant for such failure. Introducing sufficient evidence to preclude a directed verdict on each of the required elements is sometimes described as establishing a prima facie case. Sometimes this shifts the burden to the defendant to establish some affirmative defense. At other times, the burden of persuasion remains with the plaintiff, but the defendant is allowed by introducing its own evidence to rebut or negative the persuasive power of the plaintiff's evidence. To give a more detailed example of how shifting burdens can play out, consider the McDonnell-Douglas standard for establishing disparate treatment discrimination. The framework as currently applied by courts is as follows. In the first stage, the plaintiff must first establish a prima facie case by preponderance of the evidence that the defendant discriminated against the plaintiff in some adverse employment decision because of the defendant's race. Then, in the second stage, the burden of production shifts to the employer to rebut this prima facie case by, quote, articulating some legitimate non-discriminatory reason, unquote, for the defendant's decision. This is not a burden of persuasion, but merely a burden to articulate and produce some evidence of non-discriminatory reason or reasons for the decision. At that point, the plaintiff, and this is now stage 3, the plaintiff employee may prevail only if he or she can show that the employer's non-discriminatory reason is merely a pretext for the behavior and that the behavior was actually motivated by race discrimination. Even though the employer bears a burden of production in the second step, courts say that the plaintiff bears the burden of persuasion at all times. And now for discussion. In a university disciplinary setting for sexual assault, what are the relative harms to the complainant and accused of type 1, false positives, and type 2, false negative adjudication errors? And do these justify a preponderance of the evidence standard? So in today's lecture, I'm going to be talking about how to get your client paid. The successful plaintiff in a civil action will typically obtain a money judgment against the defendant. Many beginning law students are surprised to learn, though, that a judgment in most jurisdictions does not order the defendant to pay a particular sum. Rather, a judgment declares that the plaintiff shall have recovery of the defendant, the stated sum, and have execution thereof. If the defendant pays, the matter is settled. If the defendant does not pay, the plaintiff must proceed by the process of execution to obtain satisfaction from the defendant's real and personal property. A judgment gives the successful plaintiff the right to levy on any of the defendant's asset that the plaintiff can locate. The judgment often doesn't require the defendant to even cooperate by disclosing the existence and location of such assets. Execution involves a number of steps and procedures, the details of which vary from state to state. The basic objectives are to allow the victorious plaintiff to first obtain possession of defendant's assets by legally seizing the assets, by attachment, by levy, or by garnishment, and then to conduct a public sale of any non-monetary assets seized, the proceeds of which are used to satisfy the judgment. If the proceeds from the sale exceed the amount of the judgment, any excess is paid back to the defendant. Both the seizure and the sale are often undertaken or supervised by representatives of the state, for example, by off-duty sheriffs. In addition, by docketing of a judgment, a lien can be placed upon the defendant's non-exempt real property, and eventually through the sheriff or other public official. So imagine that at the end of a trial, you succeeded in securing a $1,000 breach of contract judgment on behalf of your client. The judgment would give the plaintiff a legal right not only to the judgment amount of $1,000, but sometimes also to interest in certain collection costs. You might hire an off-duty sheriff to levy, or literally seize, an automobile belonging to the defendant. You would then auction the car, being careful to follow the state's mandated auction procedures, such as giving adequate public notice of the auction. If the auction produces a revenue of $4,000, the $1,000 and possibly some interest and auction costs would go to your client, and the remainder would go to the defendant. Alternatively, judgment holders may have the right to place a lien upon the defendant's non-exempt real property. The lien, which would be uncovered by prospective buyers in a title search, would make it difficult for the defendant to sell the property until the lien had been lifted by paying off the judgment. There can be many a slip between the docketing and satisfaction of a judgment. The defendant may not have any property in the jurisdiction. The sheriff may not be able to find it. Other creditors may have liens with priority. The proceeds from the public sale may be insufficient, or bankruptcy of the defendant may intervene to extinguish the judgment itself. Consumer protection concerns have produced further pressure to limit the traditional rights enjoyed by some creditors. Nevertheless, unless the claim reduced to judgment is discharged in bankruptcy, the plaintiff normally has a 20-year renewable period to obtain satisfaction. One way for sellers to avoid the problem of having to collect on unpaid debts is to demand payment in advance. An alternative protection for sellers is to obtain a secured interest in payment. Under Article 9 of the UCC, sellers of goods on credit or other lenders can easily create, by agreement with a buyer or borrower, a security interest in personal property of the borrower and perfect it by filing a finance statement in the appropriate public office. And by the way, when you say this perfect as a verb, make sure you emphasize the second syllable. You perfect a security interest. A security interest is an interest in public property which secures payment or performance of an obligation. That's a quote from UCC 1-201B35. The written agreement creating the security interest, called a security agreement, is often accompanied by a negotiable promissory note that evidences the debtor's obligation to pay. A creditor takes the security interest in particular pieces of property, not in the debtor's entire estate. But Article 9 allows security interest in some replenishing financial assets, such as a debtor's accounts receivable. The main advantage of a security interest is speed. Due process takes time. A plaintiff with an unsecured civil claim, for example, arising out of contract or tort, needs to serve the defendant notice of the suit and then wait for an answer and proceed through discovery and wait for trial and after trial then to obtain the judgment. Only then, which often will be several months later, can the plaintiff hire a sheriff off duty to levy on the defendant's property. In contrast, a security interest holder can skip the filing and privately levy on the property without a trial. Upon default by the debtor on the note, or as defined in the security agreement, the secured party, without suing, without obtaining judgment or hiring a sheriff, may privately take possession of the property subject to the security interest, so long as such repossession can be done without breach of the peace. That said, quote, "A repo man spends his life getting into tense situations," unquote. That's a quotation from the movie Repo Man, a 1984 classic. The ability to privately take possession without delay or legal expense is the key benefit of a security interest. Subject to a limited right of redemption by the borrower and the possible claims of other lien or secured creditors, the secured creditor will usually sell the repossessed property at a public or private sale. The proceeds of the sale will then be used to reimburse the secured creditor for expenses incurred in doing the repossession, to satisfy the underlying obligation, and to satisfy the security interest in those subordinate to the repossessing creditor. As with levying to satisfy a legal judgment, any surplus proceeds from the sale of the security are then paid to the debtor. If an inadequate sum is produced, the secured party is entitled to seek what's called a deficiency judgment for the balance due, and in effect becomes an unsecured creditor with regard to that deficiency. The entire process, which can occur without the need for direct intervention by a court or sheriff, is regulated by Article 9 of the Uniform Commercial Code. For example, any public or private sale must be accomplished in a commercially reasonable manner. Basic debtor rights cannot be eroded by agreement with the creditor, and the debtor is given extensive private remedies if the creditor fails to comply with Article 9. The take-home lessons here are, number one, that judgments are not orders to pay, and two, when you give a security interest in your property, you're selling many of your due process rights. And finally, number three, because surplus proceeds are returned to the defendant, a judgment or security interest holder cannot profit from seizing more assets that are needed to satisfy the amount owed. And now for discussion. Given this last point, what was so wrong, what was substantively unconscionable about Walker Brothers Furniture taking a security interest in many more household items than it needed to secure its debt? It's common in several areas of law to distinguish between substance and procedure. It's also just as common to point out that this distinction cannot rigorously be maintained or defended. As John Hart Ely summed it up, quote, "We were all brought up on sophisticated talk about the fluidity of the line between substance and procedure," unquote. So you should be comfortable trying to distinguish between the two kinds of rules and also comfortably quick in critiquing your own attempt. Procedural rules govern how, in court, the process of litigation will be carried out. Procedural rules ordain, for example, who gets to first make an opening statement and how testimony will be introduced into evidence. Substantive rules, in contrast, determine what outcomes and consequences are supposed to flow from the facts found in the proceeding. Thus, for example, it's a substantive rule to say that a defendant commits the crime of burglary if the defendant engaged in an unauthorized breaking and entering into a building with the intent to commit a crime inside. A primary critique is that procedural rules often can be outcome determinative. For example, being the first to give an opening statement may decide some cases by causing the jury to anchor on a particular version of the events. The Supreme Court has struggled to maintain the substance-procedure distinction. When a federal court is sitting in diversity because the litigants come from different states, it is allowed to use federal procedural rules, but the court cannot, under the Erie Doctrine, use federal substantive rules. But the courts are supposed to apply state substantive rules in such settings. The substance and procedure dichotomy also arises in a host of other contexts, where courts look to the substance and procedure of others. For example, a contract is to be found void as unconscionable if it is both substantively and procedurally unconscionable. A contract that is grossly one-sided is substantively unconscionable, but to be procedurally unconscionable, courts also demand some defect in the process of contracting, such as small print that was likely to impede the ability of the non-drafter to understand what she was signing. As I record this in 2015, the United States military attacks on ISIS are, I believe, substantively defensible, but Bruce Ackerman has persuaded me that as a procedural matter, they violate the War Powers Resolution because Congress has not authorized this use of military force. Lawyers, in their interpersonal dealings, tend to become more acutely aware of the difference between substantive and procedural failures. When I complain to my lawyer spouse that she wrongly threw out an old pair of my pants, I begin solely by focusing on whether it was a procedural wrong for her to throw them away without asking me first. And now for discussion. From the Bible, try to identify procedural and substantive unconscionability with regard to Jacob's dealings with others.